Okay, thanks very much, Wendy. My
Sure.
name is Gina Tresidder, and I'm also from Russell Kennedy Lawyers, like Joe. I just joined the firm 3 weeks ago today. Russell Kennedy is a leading Australian law firm. We've got offices in Melbourne and Sydney. We've got about 270 strong offices with lawyers and support staff. And as I said, we're a full service commercial firm, but we've got particular expertise in aged care and retirement living, all levels of government, business services, health, and real estate and property development. But my area of particular expertise is intellectual property. So I deal with everything from trademarks, copyright, patents, designs, domain names, social media law, and I do all aspects of that as well. So from the strategy starting off to the registry work to commercialization and licensing to disputes. And the area for me where all of that sort of comes together is when you've got clients who are selling or purchasing a business. It's often the case when people are purchasing a business that they assume that all of the IP rights that you're using in the day-to-day operations of the business, that they're also going to be transferred along with the business. And that's not necessarily always the case. And so this is where the expertise of IP lawyers and commercial lawyers with a bit of an IP bent can really stop their clients from getting into all sorts of trouble when they're selling or purchasing a business. So there are 3 key steps in any commercial transaction that all commercial lawyers will probably be very familiar with. The first one is pre-transaction due diligence. Then we've got completion, and then we've got post-completion. And there are specific aspects of those where you need to involve your IP lawyers. And I'm going to go through them one at a time. A bit of a whirlwind very quickly. So starting off with due diligence, which we're all probably familiar with, this is where the vendor checks to make sure that they haven't got any skeletons in the closet that the other side's lawyer is going to find. And the purchasers' solicitors make sure that the vendor is actually getting what they think they're getting in the transaction. So from an IP perspective, the first thing you need to do is actually identify all of the IP assets that are being used in that particular business. And this can be the really obvious things like all of the clothing designs for a fashion company, or it can be the recipes and the brands for a fast food retailer. But don't forget all of the back of house IP assets that can also be really important. So for example, you might have a logistics company and the whole company is run based on this proprietary software. And without that software, the company just can't run. So that's a key IP asset. Or if you've got a franchise which has got, hundreds of franchisees across the country, the operations manual can sometimes be about that thick, and it takes hundreds of man hours to put that together. So the IP rights in that operations manual are also really key. So once you've identified all those IP assets, the next thing is to make sure that you know who owns them. And don't make any assumptions. You always have to check. I've been involved in numerous transactions over the years, and some of the examples where the IP assets didn't sit with the vendor might include where you've got a startup company and they might have filed all their patent applications in the name of the director, the inventor, the original inventor, before they actually incorporated their company. And you might find that they never actually assigned any of those patents across to the company that they're selling. Or another one that I dealt with was where there was a really valuable international trademark portfolio. They had hundreds of trademarks registered all around the world, and they were going to sell those along with the business. But when they actually came to doing their due diligence, they realized, well, we got this portfolio from another business that sold it to us. And when they sold it to us, we never actually recorded that transfer on any of the registers around the world. So we don't have actually any way to transfer those trademark registrations across to the buyer. So that was a huge mess that needed to be sorted out. Another example, if we go back to the logistics company example that I gave, where the company was really heavily reliant on this proprietary software. That software, the developer of that software, was actually a consultant to the company, not an employee. And under Australian copyright law, that means that the copyright in that software is retained by the consultant. It's not owned by the company, even though the company commissions the software. And a final example that I've got is where the business was getting all ready to launch, and the launch was all based on a particular domain name. They had a website at a particular domain name. It was really jazzy. It was really sexy. They were committed. But they realized that the person who had actually registered that domain name for them was the head of IT, and he'd done what people often do, and he'd registered it in his own name instead of in the name of the company. Relationship soured. He ended up getting fired, and I got on the phone to him and said, you have to transfer that back to us. And he told me, that's your problem, that's not my problem. And so we sued him and we got it back. But of course, that was a huge delay and a huge concern to the client at this point of launch.
2 minutes.
Sorry?
2 minutes.
2 minutes. Okay. So once that you have identified those IP assets, you need to confirm that they're not encumbered in any way and that they're not restricted in any way by any sort of exclusive licensing arrangements and things like that. Now, the next step is completion. And completion is where all the documents are exchanged and everybody signs everything. And it's important that you make sure that you're going to get all the documents you need to record the transfers on the relevant registers. And this can be really important because in Australia, our registers are really relaxed. We can probably lodge all sorts of things, but there are other registers around the world. You need original documents, you need them notarized, you need them legalized. And once completion's taken place, the vendor is not going to want to cooperate with any of that. Also, companies get deregistered, people die, people move away, and you're not going to be able to get those documents. Then the final thing for post-completion is make sure you record all of those assignments, but also make sure that you've got IP experts who are responsible for all of the trademarks, patents, and designs to make sure they're monitoring all the deadlines. Because even if you record the transfer, if you've got pending applications, they can lapse. If you've got registrations, they can expire, and your client can find that they've spent millions of dollars on an IP portfolio, which is now essentially non-existent. So that's just a quick whip round of the IP things that you need to consider when you're selling your business. Thank you.